right, very good. So let's think about that for a while. That makes a lot of sense. Okay, so now we're going to move over to our final section, our key takeaway section, if you will. And just by way of reminder, what I'm going to do is ask each of the speakers, in the order in which you presented, to give the audience a couple of key takeaways, things that they really should, if they're going to retain anything from their presentations today, emphasis areas, things they should take with them. So we'll go ahead and start with Heather Johnson from the FTC. Heather, would you like to give us your takeaways, please?
Sure. So from my perspective, the key issues here are what we're really looking at with these reverse payments is the core antitrust question, which is, did the payment induce the generic to settle its patent litigation and not continue to litigate, and therefore eliminate the risk of what might be uncertain competition? That is what our antitrust laws are focused on, ensuring that competition occurs. The other aspect of this that I feel like I've hammered on a little bit is that the patent is not, the outcome of the patent litigation is not relevant to the ultimate antitrust liability. And so relitigating that turducken patent issue is no longer something we are doing in the wake of Actavis. And finally, the third thing is, with respect to economic incentives, there certainly are huge economic incentives for companies to engage in these reverse payments. In terms of, from an economic perspective, how you should look at this in the post-Actavis world, there is an article that I found very useful called "Activating Activists" by Carl Shapiro, who is an economist, along with Scott Hempel and Aaron Edlin. And I would, for those who are interested in thinking about this from an economic perspective, I would encourage you to address that article and read that article if you can.
Thank you very much. That was Heather Johnson over at the FTC. Thank you for giving us those final thoughts. Let's go to Ted Davis over at the Analysis Group.
Thanks, Tom. I think I'll just be brief and just say, my views again are, the nature of the inquiry. Certainly post-Actavis has changed a little bit. I think the role of the economist is a little bit different now than it used to be. I still think, we may not need to be eating any turducken anymore going forward, but I do think patent merits do still matter, and they are still relevant as you start to take these cases past, the motion to dismiss phase and start to get into merits. Thank you.
Thank you, Ted. That was Ted Davis over at Analysis Group. And finally, let's go to Fabian Leingruber from Thalmann Fisher.
So I think it's worth to mention again that the Actavis decision triggers the competition law development worldwide. This is important to see, this connection. However, the assessment of reverse payment agreements is complex. This is in the international context even more. So this is true for the U.S. Application of the rule of reason, but it's also true under the European Union law by assessing the Article 101 violation by object. So assessment cannot be done in neither market easy. It's very complex. And the third takeaway is that when a certain limit of payments, reverse payments, are reached in a settlement agreement, and if you have a certain linkage within, you must be very careful in any market worldwide, in any of the major markets, be it in the U.S. market or in the European Union market or in the Asia-Pacific market. So this is a major point of my presentation.